as the stage gets set for perhaps one of the most intriguing sessions of the Assembly of State Parties tomorrow, changes in the way the International Criminal Court works are now gathering a lot of attention. The ICC's strategic plan, which runs from the year 2012 to 2015, will see the court focus on deepening its experience in the prosecutor's office, among other things. But of key interest to Kenya are two changes. One that critics say was informed by the Kenyan cases, and the other which could very well inform how many Kenyans could stand trial at the ICC going forward. John Alanamu spoke to the ICC's Deputy Prosecutor James Stewart about these plans.
A wind of change is blowing at The Hague.
They have been worked on for several months.
Not that which will bring Kenya's proposed amendments to the rules and procedures of evidence, but changes within the International Criminal Court itself.
States sacrifice some measure of sovereignty by becoming parties to the Rome Statute, and that's...
Speaking at a conference focusing on the legacy left by the International Criminal Justice organs, Deputy Prosecutor of the International Criminal Court, James Stewart, outlined various changes in the manner in which the ICC will operate, all detailed in a strategic plan, but among them was this.
The new strategic plan for the Office of the Prosecutor contemplates the possibility of investigating people at a little bit lower level than the top level, if you will.
This means that in the event that the ICC is called in to investigate crimes under its jurisdiction, it would be looking to bring to justice the wider nexus of perpetrators of those crimes, and not just those at the top. Could this apply in Kenya's case? The answer is yes. Were evidence to point to middle-level perpetrators of crimes under the ICC's jurisdiction during the post-election violence, then new cases could be made against more local perpetrators.
That for good tactical reasons, because it's often difficult to reach people through the evidence who we may suspect as being the most responsible, and yet there are people who are right out there that we could deal with.
And in the absence of local judicial proceedings to try middle-level perpetrators, it's believed that this could help address what is being called the impunity gap. That is, the void left if only those accused of bearing the greatest responsibility for crimes are tried. The ICC, though, cannot go down as far as to try those physically responsible for the crimes.
Other inhumane acts within the meaning of Article 7(1)(k) of the statute.
And on its collection of evidence, the ICC is considering having more robust investigations driven by itself, seemingly in preference to reports compiled by NGOs and human rights organizations. Stewart, though, still considers evidence from these bodies as a key element in the ICC's building of its cases.
Because of the way in which the court has to operate under the Rome Statute, we're not the first people on the ground. And very often the first people on the ground, so to speak, and who may be direct witnesses or have even suffered the violence that is of concern, are the NGOs, our civil society. And often within countries, they're the ones who are outraged by what happened and want to see something done.
Stewart was non-committal about whether these changes were informed by the goings-on of any cases currently before the ICC, including the Kenyan cases. But given the public debate on the strength of the Kenyan cases based on evidence presented so far, some may be making those conclusions for themselves. John Alanamu, KTN.